Hi, I'm Charity MacPherson with Village and Shoreline Properties, and I'm here with attorney Eric Janney from the law firm of Block Janney in Sicily. They have offices in Norwich and Mystic. And we're going to talk just a little bit about the real estate transaction and why we use an attorney to facilitate the transaction in the state of Connecticut and other states in the country also. So why don't we discuss what the attorney does during this transaction to transfer the ownership of a property in
and thank you for having me. The practice of real estate in Connecticut has evolved over many years to involve attorneys in the closing process, in part because otherwise you're making one of the biggest investments in your life and you don't have someone necessarily there advocating for your interests, knowing the law, being able to negotiate disputes or issues that may arise, not even just at the closing table, but before. As opposed to a settlement agent through a title company in other states, that person is there just to conduct the closing. They are not representing you, buyer or seller. They are just the person that is conducting the closing, handling the disbursements, handling the paperwork. So I believe that it's advantageous to clients knowing that they have somebody on their side to represent their needs and their interests and to argue on their behalf should there be any need to do so.
Yeah, absolutely. And a lot of times I'll recommend clients even have their attorney look over the documents just to make sure that all their interests are represented in the best way for them. So there are different types of deeds to have on the ownership transfer documents. Let's talk about different types of deeds in terms of the...
The most common deed, if there are multiple purchasers, whether they're married or not, would be as joint tenants with rights of survivorship, meaning that you each have, if it's two people, a 50% indivisible interest in that property. So should one of the joint owners pass away, title to that property would vest automatically in the survivor of the two or three, how many ever people are on the deed. As opposed to tenants in common, which means if there are two people owning as tenants in common, you each have a 50% divisible interest in the property, so that should you pass away, title would go through your estate to whoever you've named as your heirs. Again, usually with a married couple, joint tenants with rights of survivorship is the preferred methodology. There may be estate planning reasons or other reasons why we wouldn't do that. And tenants in common, again, sometimes for estate planning reasons, but unrelated parties holding property together might be more likely to be holding it as tenants in common. And then thirdly, we often have clients take title in a business entity, especially if it's an investment property or a second home. They may create a limited liability company, an LLC. So that is the title goes into that entity and that entity alone, and then the owners or members of that LLC would have a separate agreement, an operating agreement amongst themselves that would determine the issues such as, well, what happens if one of the members passes away.
Okay. And then when I'm writing a real estate contract on behalf of my buyer client, typically I will put a warranty deed in the transfer of the property. What does that mean as opposed to some of the other deed types?
The warranty deed is our highest form of deed. It says that the seller in conveying the property will warrant and defend the status of the title to the buyer, so that it's protecting a buyer from any claims or encumbrances unless they are stated in the legal description of the deed, as opposed to a quitclaim deed, which is our lowest form. A quitclaim deed in essence says the seller is not promising you anything about whether he or she owns the property. I could give you a quitclaim deed to the land under the Brooklyn Bridge. I'm not promising that I own it, but whatever interest I may own, I'm conveying to you in that quitclaim deed. So that's the key difference. A warranty deed in residential transactions, third party, arm's length transactions will use a warranty deed.
And then I know sometimes attorneys will recommend or highly recommend additional title insurance above and beyond what is required by the lender. What would that mean and how would that protect the buyer?
Sure, there are two types of title insurance policies. And the thing about title insurance is when you're purchasing a piece of real estate, you're not just purchasing the structure and the land under it. You are purchasing that property's legal history, which is why a title search is critically important to be done to determine the status of title, what liens may exist, what easements may exist on the property, so you get a sense of the legal history of the property. If you are getting a mortgage, your lender absolutely will require a lender's policy of title insurance. That only protects them. It just says that the mortgage is validly executed under the laws of the state, and it's in a first lien position or second lien position, depending on
They
whether
come
it's a
first.
first or second. They do. So if you do not have the optional owner's title insurance policy, none of your equity is protected should there be any claims against the title. It's a risk analysis. What's
Right.
the likelihood that there be a challenge to the title? But very often, if your mortgage amount and your purchase price are not dramatically different, so you have a smaller amount of equity, that owner's title insurance policy is
Yeah.
not going to be that more expensive. And both policies, it is a one-time premium. It is not like homeowners insurance. You pay it once
That's an
at the
important
time
point.
of closing.
Yeah.
So from a cost-benefit analysis, it really helps. I've had a number of situations where you wouldn't ever think that a problem
Yeah,
could
you
arise.
just never know.
And they do. We wrestle with them all the time, and so we strongly recommend that you purchase that owner's title of policy.
At the
as
very
well.
least, discuss it in detail with your attorney at your closing before you make a decision.
Right, and we'll discuss it with
Yeah.
clients ahead
Yeah.
of time.
And I know you do. It always comes
Because
up.
it's a question, well,
Yeah.
what does this do for me? So it
Yeah.
protects your equity in the property. There are any number of scenarios that an owner's title policy will cover, and the title company will protect you, hire somebody to clean up the defect. Whereas with the lender's policy, they're just indicating what the status of that mortgage, and it protects the lender's interest, their mortgage amount, but not your equity.
And this barely even covers half of what goes on during the transfer of a piece of property in real estate. So that leads actually into some of the other services that your law firm offers, wills
Sure.
and all kinds of things.
Yes, we're a law firm that handles personal representation. So we'll handle business matters, estate planning, wills, trusts, and the like, estate administration, probate, handling people's estates, business disputes. So we do commercial litigation as
Okay.
well, and commercial banking. So it's a practice that is what we call personal representation and then business representation.
Okay, and I can say, our firm does a lot of business with Eric and his partners, and definitely our clients have all been very satisfied at this point so far. So thank you very much, Eric. I appreciate your time, and we'll talk to you again soon.
Thank you.
Thank you.